purport to vest the power of verifying and tallying presidential election results as received at the National Tallying Center solely on the chairperson to the exclusion of other members of the commission, the same is contrary to and inconsistent with the provisions of the Constitution. That said, we, however, take cognizance of the fact that the 4th, 5th, 6th, and 7th respondents, referred to as the 4 commissioners, actively participated in the verification and tallying exercise from the beginning up to and until just before the declaration of the results by the chairperson. They took turns announcing the results as verified and tallied, and were present and active during the actual verification and tallying at Bomas. An example is when one of them, Justice Nyangaya, stood on the podium to announce to the public results and also announced an adjustment that had been occasioned by errors of tabulation. The events of 15th August 2022, therefore, came as a surprise. As the public waited for the chairperson of IEBC to declare the final results, sporadic violence broke out at Bomas. The violence swiftly was contained by the security forces, but there was unexpected drama as 2 different factions of the commission began to emerge. Kenyans found themselves watching an appalling split-screen scenario on their television sets. On one part of the screen was the chairperson readying himself to declare the results in accordance with Article 138(10) of the Constitution. On the other part of the screen were the 4 commissioners on the runs of the Serena Hotel, Nairobi, from where they announced that they would not own the results that were soon to be declared by their chairperson. The 4 commissioners informed the public of their rejection of the yet-to-be-announced results, terming them opaque due to the manner in which the chairperson had been conducting the verification and tallying exercise. In his affidavit dated 25th August 2022, Justice Nyangaya averred that the chairperson's actions during the tallying and verification exercise at Bomas made it difficult to ascertain the total number of votes cast and the actual number of votes attained by each candidate, so as to enable him authoritatively state the commission and declared accurate results. All the petitioners have anchored their arguments for the nullification of the 9th August presidential election in Taharia on the walkout from the Bomas by the 4 commissioners. They contend that by rejecting IEBC's results on grounds of opaqueness of the verification and tallying process, they called into question the credibility of the entire election. They further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional commission cannot deliver a credible election. We note that apart from their 11th hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. Critically, they have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that Thus far, the entire election had been managed efficiently and credibly. The chairperson, on his part, did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy, an institution that obviously needs far-reaching reforms, of which we shall say more in our detailed reasons. But are we to nullify an election on the basis of a last-minute boardroom rapture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people are participating without hindrance, as they made their political choices pursuant to Article 38 of the Constitution? To do this would be tantamount to subjecting the sovereign will of the Kenyan people to the quorum antics of IEBC. This we cannot do. Clearly, the current dysfunctionality at the Commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the four commissioners, IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution. Issue number 7, whether the declared President-elect attained 50+1 of all the votes cast in accordance with Article 138 of the Constitution. The first, second, and third petitioners averred that the first respondent did not garner 50%+1 of the total votes cast, and therefore did not meet the threshold provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50%+1 of the votes cast, this ought to be calculated based on the total number of votes cast, excluding rejected votes. They argued that 50% of 14,353,165 votes, in their view, were the valid votes cast, which amounted to 7,176,582.77 votes. They therefore contended that by attaining 7.176141 votes, the first respondent did not meet the constitutional threshold to be declared president-elect. Supporting the claim that the first respondent did not meet the 50+1 constitutional threshold was the sixth petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IEBC after the official closure of voting on 9th August 2022. According to the sixth petitioner, the chairperson of IEBC announced that the voter turnout was 65.4% of the total number of registered votes based on the verification of the KIMS kits which were functional during the process of voting. In addition, the sixth petitioner urged that the voter turnout of 65.4% did not include some 238 polling stations where the KIMS kit and malfunctioned, necessitating use of the manual register. It was therefore urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, that this number was bound to increase once the number of votes from the areas that used the manual register were included. The sixth petitioner further claimed that a summation of the minimum number of votes cast and unturned manual votes would represent the actual voter turnout. In challenging the declaration made by the chairperson of IEBC, the sixth petitioner warned that the final tally, published in Form 34C, only accounted for 14,326,641 votes cast, including some 113,614 rejected ballots. The sixth petitioner contended that this tally did not factor in some 140,138 votes cast using the manual register. The sixth petitioner computed this number by subtracting 14,326,641 declared votes cast from 14,466,779 generated by the sixth petitioner as representing 65.4% of the voter turnout. Referring to the tallies in Form 34C, the sixth petitioner summed the number of votes cast for each candidate as follows: Raila Odinga, 6,942,193; William Ruto, 7,176,141; Wahiga Mwaura, 31,987; and George Wajakoya, 61,969, adding to a total of 14,213,027. He then added 140,138,000 arranged to be unturned votes, and this yielded a total of 14,353,165 total valid votes, which the sixth petitioner used to compute the percentages garnered by each candidate as follows. William Ruto, according to him, garnered 49.9%, Raila Odinga 48.3%, Wahiga 0.22%, and Wanjakoya 0.3%. It is on this basis that the sixth petitioner grounded the claim that none of the candidates met the constitutional threshold as set out in Article 138(4)(a). IEBC and its chairperson disputed the sixth petitioner's claim. They submitted that the declaration of results is based on the number of people identified as having voted on the KIMS kit and not the total persons on the voters register as arranged. They contended that the final voter turnout, comprising of the voters who were identified through the KIMS kit and those who voted manually, was 64.76% and not 65.4% as arranged by the petitioners. They urged that the announcement earlier by the chairperson of IEBC on 10th August 2022 was immediately clarified during the same press briefing. And evidence of this correction was provided to this court in an affidavit of the first and second respondents in Presidential Election Petition number 7 of 2022. According to IEBC and the chairperson, 14,239,862 voters were identified using the KIMS kit, while 86,889 voters were identified using the printed voter register. Therefore, the total valid votes cast were 14,213,137, while the total number of rejected ballots were 113,614, constituting 14,326,751 total votes cast. They illustrated that the first respondent garnered 7.176141 votes against 14,213,137 total valid votes cast, yielding a percentage of 50.49 to meet the requisite constitutional threshold for a candidate to be declared president-elect. In the upshot, the percentage attained by each candidate was as follows: Raila Odinga 48.84%, William Ruto 50.48%, Waiga Mwaure 0.22%, and George Wanjakoya 0.43%. IEBC and its chairperson also submitted that the KIMS kits malfunctioned in 235 polling stations, necessitating the use of the printed voter register. In these polling stations, backup KIMS kits were later deployed for purposes of results transmission. The first respondent, in response to the question of 50+1 constitutional threshold, maintained that he attained the threshold under Article 138(4) of the Constitution as elaborated by the IEBC and the chairperson. This court has considered the differing formulas and threshold arguments presented by various parties to this petition, while the first, second, and third petitioners raised pertinent questions connected to this issue. We shall address them together with those of the sixth petitioner, who has addressed and focused on the issue as specifically framed in detail. It must be restated that the case made by the sixth petitioners concerns a data-specific threshold as enunciated under Article 138(4) of the Constitution, that without attainment of which there can be no declaration. This data-specific threshold is what this court declared in John Arun Mwau and two others versus IEBC and others. Petitions numbers 2 and 4 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IEBC, petition number 5, 3, and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% plus 1 of the votes cast in accordance with Article 138(4) of the Constitution. Similarly, in the same Raila 2013 case, the court further laid down the parameters of burden and standard of proof in electoral disputes. More specifically, the burden and standard of proof required in disputes challenging the outcome of a presidential election. And this is what the court said, I quote, "In the case of data-specific electoral requirements, such as those specified in Article 138(4) of the Constitution, for an outright win in the presidential election, the party bearing the legal burden of proof must discharge it beyond any reasonable doubt." The question that follows was whether the petitioners challenging the attainment of 50% plus 1 constitutional threshold and the computation by the sixth petitioner in general met the standard of proof settled by this court in Raila 2013 case. The premise of the sixth petitioner's percentage computation was a press briefing made by the chairperson of IEBC on 10th August 2022, when the evidential burden shifted to IEBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not include reports from all the KIMS kits and 86,889 voters who were identified manually using the printed register of voters. In our view, the assertion by the sixth petitioner that the percentage voter turnout was firstly predicated on the uncorrected percentage given by the chairperson of IEBC was negated by evidence adduced to prove the correction. Secondly, the sixth petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IEBC made reference in the press briefing to the number of registered voters who were identified through the KIMS kits progressively. The sixth petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional. We have deliberated on this proposition and found that it is not mathematically sound and that the rounding off done by IEBC and its chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through KIMS kits progressively and used by IEBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IEBC applied the formula in Article 138(4) of the Constitution, which is total votes cast less rejected votes divide by 2 must always give 50% plus 1 vote. Given the numbers that were presented to us by IEBC and the chairperson, this will translate to 14,213,137 divided by 2 plus 1, which makes 7.106569. The question that must inevitably follow is whether this formula, when applied, will confirm that 7,106,569 votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IEBC and its chairperson and the declaration by the chairperson of the President-elect on 15th August 2022, it is our finding that the declared President-elect attained 50% plus 1 of all the votes cast in accordance with Article 138(4) of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EO preparation by the IEBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear and determine disputes relating to the election of the office of the President arising under Article 140. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the President-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition, and across 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the President-elect to be invalid, a fresh election shall be held within 60 days after the determination. In exercising its jurisdiction pursuant to these provisions, the court sits as an election court with a mandate to determine the validity or otherwise of the election of the President-elect. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders or reliefs it can grant following the hearing and determination of the election petition under Article 140 of the Constitution. In the event the court determines that the election of the President-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing IEBC to hold a fresh election within 60 days after the determination. Should the court determine that the election of the President-elect is valid, it shall issue a declaration to that effect. The court has then, as a matter of course, to make an order dismissing the petition with or without cost, as the case may be. In the strict sense, therefore, these are the only orders that the court may make under the Constitution. The court cannot assume jurisdiction that goes beyond the purview of Articles 163(3) and 140 of the Constitution. However, nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the President-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the amici curiae, and the court places a heavy premium on those briefs that were filed and those which were admitted. The final orders made by the courts. This is a unanimous decision of the court, and we make the following orders. 1, the presidential election petition number E005 of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as President-elect to be varied under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered. And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by counsel in these proceedings, and also the orderly way the counsel, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case. I think that is all. Thank you very much for coming.
My Lady, Madam Chief Justice, and the learned judges of this court, again, I am requested by my colleagues to thank you most profusely for your labors into delivering this judgment, listening to all of us, and giving our nation this judgment so that we may move forward. Thank you, and God bless you.
It may please the court. It is not true that I asked the Attorney General Emeritus to talk on our behalf. Next time you should talk to me. Let me similarly, on behalf of the lawyers for the counsel for the first and second petitioner, thank the court. It has been a journey, worthwhile journey, sitting through these proceedings, and we thank the court for your patience and for the delivery of this judgment within the time stipulated. We thank you.
Madam President, members of the court, I wish to request just a couple of minutes for the chairperson of the Law Society of Kenya to make a few remarks in appreciation of the work that the court and Kenyans have done on this exercise, if you allow. Thank you. I call upon Mr. Eric Theuri to come and make his remarks. It is also his birthday. I would have sung happy birthday for him.
My Lord, the Chief Justice of the Republic of Kenya, the President of the Supreme Court, the Deputy Chief Justice, and all the justices of the Supreme Court, I think it would only be fair that I make my remarks after counsel for the respondents, Senior Fred Ngatia, makes his remarks to the court.
Madam Chief Justice, thank you very much. It's so kind for the President to acknowledge that age goes before youth. Mine is to thank the court, to thank my learned friends for the effort we all expended. We thank this court for clarifying certain issues, and we look forward to a less corrosive 2027. Thank you very much.
Madam Chief Justice, Madam Deputy Chief Justice, it's so nice to have two madams at the same time, and members of the court. Since there are only men talking, I decided that I should become a woman and talk. It's becoming too much of a male affair in here. But on behalf of I think we were the third petitioner, I wish to thank you and you've clarified the Regulation 87.4, which I was feeling very passionately about, that it was unconstitutional from what I've heard. But thank you very much for the time you spent, and we do apologize if at times we looked like hooligans. I mean, you have said we behaved well, but we didn't behave as well as we should have. But thank you very much for your time and for delivering this judgment.
Madam Chief Justice, Madam Deputy Chief Justice, members of the court, I, on behalf of Attorney General, take this opportunity to thank you most sincerely for a great job done and for the courage to clearly define the limits of the law, which will help us empower IBC on the way forward, and hope that this might be the last of the petitions after elections once we carry out a proper elections based on your guidelines. Thank you.
The Chief Justice and the Justices of the Supreme Court, on a light note, my members would be extremely worried if we take the submissions of Senior Counsel Orengo that this should be the end on account of fees. But Baleli, the Chief Justice, on behalf of the Law Society and all the members of the society, we wish to, first of all, take this opportunity to thank the court in the manner in which it has conducted these proceedings, extremely efficient, especially in light of the really short and strict timelines that you've had. But the management of the proceedings, the manner in which the court adopted a somewhat inquisitorial nature to the conduct of these proceedings is something that as a society we have noted, and we wish to commend the court. And we do hope that the other courts, as they determine any petitions, election petitions that would go before them, will similarly adopt such inquisitorial attitude, so that we try and really enrich the process that these proceedings intend to achieve. Secondly, I wish to also thank the council, all the advocates who have appeared before you. They have demonstrated extremely high standards of decorum and courtesy, and have also demonstrated a flair for persuasion of the court, including the use of PowerPoints, and of course the now famous Pinky Pinky Ponky mimic. But all that really, I'm sure, has demonstrated, especially to the younger members of the society, how to conduct themselves before the court and how to really prepare a persuasive brief. And we thank all the advocates who appeared before this court for the good work that they have done. And of course, as a society, we feel extremely proud that they have been able to raise the profile of the advocates in this country a notch higher from their presentation. So, my lady and my lord, it's not lost to us that at the end of these proceedings, and once we are able to get your judgment after 21 days, that it is democracy and the Kenyan people who are the winners. The decision today, in a way, validates the choices that were made by the Kenyan people on the 8th of August, and they also help to build confidence in the institutions that manage the elections and the court. We recognize that no country is born as a democracy, and that it is a process, and the process of challenging an election, as has happened before this court, is part of the processes of building confidence within the electoral system, and we thank all the petitioners for choosing to challenge the results before this court. But at the end of the day, Kenya stands tall as a beacon of democracy, and we are very grateful that we've had this opportunity also as a law society to appear before the court and to give an amicus brief which the court has had time to consider. So we thank you and we wish you a good day. I know it has been a long 14 days, but you can rest, and we'll be looking forward to the decision that you deliver within 21 days. Thank you so much, my lady and justices of the Supreme Court.
Thank you, Mr. President. I have been asked by the President of our court to react to your submissions, and in so doing, I am obliged to say that we are truly humbled by the statements that you have just made. More humbled because those statements come from both sides of the divide. And thank you for appreciating what we have to do within a very short while. Thank you for appreciating that it wasn't our wish that we were doing what we were doing. We were doing the wish of the Constitution of Kenya 2010, the laws of the Republic, the facts of the cases that you placed before us, and the evidence in rebuttal. We know that, and we have repeatedly said this, the President and I, whenever we have had time to talk to you in other fora, that we are incomplete without this side of the bar. We are incomplete without the advocates. We thank you. We will get opportunity to do that in the main judgment, in the reasoned judgment. But we really appreciate your industry. We were impressed by the submissions you took. And we were impressed, and we said this the last 3 days, I'll tell you something about that in a minute, by how deeply you believed in your clients' cases. That we think is a mark of an extremely grown legal profession, and we ask that you do not bring the bar down. You keep taking it up. In any contest of whatever nature, and even if we say there are no winners and losers, and even if we say that the winners are the Constitution and the people of Kenya, the truth is that some 6 million Kenyans will not be happy today. But that's the nature of the work we do. What we hope, and we hope you can advise your clients and our brothers and sisters that are the Kenyan people, that that is what was expected. One side had to win. One side had to be in total or a great extent of compliance with the Constitution and electoral law than the other side. That's how we saw it. We thank you very much. We, the 7 of us, have not slept since we parted company on Friday. I think it is showing on our faces. And we thank you that you appreciate that we work under difficult circumstances, especially because of time. As ground rules, we agreed when we left you here on Friday that we would not pick any of your cause. A lot of you called us, but we just couldn't pick your cause. And I hope you understand that we couldn't. We saw that you were trying to call us, but we just could not pick the cause. I hope you understand. And now if you allow us, again, on behalf of these 7 men and women, thank you very much for appreciating what we have to do. Thank you for giving us the honor to serve this country in these capacities. And let's hope that we can continue to grow our democracy this way. And thank you very much for everything you also do for the country. And now you allow us to go home and sleep.
Thank you. The court is adjourned.
Very well, there you have it. William Samoei Arap Ruto is officially Kenya's 5th president after that win. His win was affirmed by the apex court there. They say once you've cleared the bush, you cannot hide it in it anymore. Where the apex court judges have cleared the 9 bushes that were standing between William Ruto and his win, and given the clean bill of health to the Independent Electoral and Boundaries Commission. While there are some issues here and there at the IEBC, yes, but that did not warrant the annulment, and they have affirmed that democracy and Kenyans are the winners. All the 7 judges, it was a unanimous decision, all the 7 judges have upheld that win. Ray?
Indeed, yes. I was just thinking about those 9 bushes there. And there was one of the issues that rather came out, and this one we actually even saw.
Yeah, indeed, William Ruto is the president-elect, and as soon as he is sworn in next week on Monday, then he officially gets into the Kenyan history books as Kenya's 5th president. That is after all the 7 judges said yes, indeed. And talking about bushes or the petition, the final orders being the presidential petition has been dismissed. The election was valid and carried out in a manner that was free, fair, and verifiable. And as you can see from the pictures on your screen live from Uasin Gishu, Yosonyeri, and Milimani, and let me correct myself there, well, the swearing in will be next week on Tuesday. As you can see, jubilation in Nyeri, the yellow colors, the people there, the UDA colors, the UDA logo there, people celebrating the win. It's not anything different from the picture above that is in Uasin Gishu. As you can see there, people had to brave the heavy rain, the heavy downpour in Uasin Gishu to ensure that they listen keenly to one of their own, William Ruto, hailing from that county. And as I had alluded to earlier, is that all the 9 issues have been dispensed with. And talking about the technology failing and integrity verifiability, that has also been dismissed. Actually, one of the key issues that all Kenyans we were looking at is the 50+1. And from what the judges have talked about there, giving us calculated and verified reports say that yes, indeed, William Ruto did hit the 50%+1 as required by the law. And also, did the irregularities affect the final outcome? Yes, indeed, there were here and there, but that did not warrant the irregularities did not warrant the annulment of that presidential election. Was there interference, transmission of Form 34A, uploading of Form 34A? No evidence presented, according to the 7 judges, to show interference on the form before or during the uploading. That has also been dispensed. And also, they're talking about the postponement of the election in 8 electoral units. That has also been acted upon and said it was a genuine mistake and IEBC should have examined the template, but it was not a calculated move to suppress voters in the 8 electoral units. Another issue that has been dispensed with is whether the IEBC tallied verified results as required in Article 138(3) and 138(10) of the Constitution. Yes, indeed, they did that. Right?
Now, some of the issues there, and I'd want us to zero in on that one of the fifth, actually the number 5 of the issues, whether there were unexplainable discrepancies between the votes cast for the presidential candidates and other elective positions. This is an issue that has perennially been questioned whenever we've had presidential petitions. We saw this happen in 2013, we saw this happen in 2017, and also now in 2022. But now issue number 6 on the conduct, and this heavily lied on the conduct of the IEBC as the agent that was in charge or in as far as oversight is concerned, whether IEBC carried out the verification, tallying and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Here we had the 7-judge bench actually go further to even issue a recommendation, and I'd want to paraphrase there with the CJ, their Chief Justice Mahakama, saying that there are far-reaching reforms required of the IEBC, and thus pointing at serious grievances in as far as governance of the IEBC is concerned. However, no information shows that the election was compromised, and also questioned the participation of the dissenting 4 commissioners there, questioning why they participated up until the last minute. And very curiously there, she further pointed out and said that it was a last minute, an 11th hour boardroom rapture. I'd want to bring in the views of our lawyer here, Gibson Gisore, in regard to that particular issue, the verification, tallying and declaration of results, and the implications it has therein into the conduct of the IEBC and also the conduct of the chair. These have been adversely mentioned by the petitioners and now the judges while actually doing the pronouncement of the verdict therein. So what is your take in regard to that, Gisore?
Regina, I think first, before I go into into answering your question, let me congratulate William Ruto the 5th, because that is now a momentous occasion for the country, because there has been an issue. We have been through this electioneering period for the longest, now that we have a president-elect, substantive.
Now, talking about a president-elect, our viewers, what you're seeing on your screens is live pictures from the current residence there. We are also having live pictures from the, that is Nyeri jubilation, as you can see. Kenyans celebrating now the Supreme Court there, unanimously upholding the election of William Ruto as the 5th president. He's currently William Ruto president-elect. We expect that the swearing in is going to take place within 7 days after this particular judgment has been made. That makes it effectively September 13th. That is Tuesday. On your split screen there, you're having different views there. We have Nyeri there in celebration. We are having sights and scenes also from current residents, and we are also having pictures from Uasin Gishu County, County 2, 027 there, and in Eldoret. Seemingly a calm crowd there celebrating that particular decision by the IEBC, by the Supreme Court there, upholding the election of the country, so to speak, in various strategic counties as well as towns there, to just look at what Kenyans have to say and what is the general mood. This was highly anticipated. Noon was a time that was slated to have the decision, and the decision has been rendered unanimously, so to speak, by the Apex Court that has upholded the election of William Ruto there as president-elect. Those are live pictures from Karen, where we expect that the president-elect William Ruto is going to be giving his address, the first after the delivery of the judgment in this petition there. This particular petition had 9 issues, among them the issue of interference, whether technology deployed by the IEBC in the elections met the standards of integrity, verifiability, security and transparency. All the 7 judges there unanimously making the decision and saying that all the 9 key issues, there was no substantive evidence to nullify the election. And such, we have William Ruto as the president-elect, and those are live pictures from Karen, where he's expected to take to the podium anytime from now to address leaders under the Kenya Kwanza coalition there, as you can see, as well as affiliate members who are already at the current residence, anticipating to hear from the president-elect, William Ruto there. That's the residence. And we can see contingent of security apparatus already there. We can see GSU as well, some plainclothes police there, just trying to ensure that the stage and the area itself is secured, awaiting that particular address. We're also having leaders there, as you can see. We're zooming in on Kirinyaga, governor-elect there, as well as Ken Lusaka there. We're also having some members of the communication team under Kenya Kwanza there, led by former journalist Mohamed Hussein there. We're also seeing Alfred Mutua and ANC leader Musalia Mudavadi there, among the Kenyans who are eagerly anticipating the first address there, so to speak, after the delivery of the judgment of the presidential petition after the August 9th polls. Earlier on, we were just having views from Kenyans across the country. We gave you a look of how things are looking at in Eldoret Town, Uasin Gishu County, as well as Nyeri there and Kirinyaga, and also just a sneak peek into activities down at Kencom area, the Central Business District, where we have our reporters who have been just keenly looking at how the country is looking at. Now we soon let's have a listen into what Kipnusu has for us there down from Eldoret, Uasin Gishu. Kipnusu, good afternoon.
A very good afternoon to you, my colleague there at the Broadcasting House in Nairobi. Yes, indeed, I'm coming to you live from Uasin Gishu County, one of the counties where all eyes have been focused on, bearing in mind this is the home county of the president-elect William Samoei Arap Ruto. And residents here have been eagerly awaiting this proclamation from the 7-judge bench, and they have been here enduring heavy downpour, just watching a big screen mounted here in the CBD. And after the after the announcement from the 7-judge bench, of course, from the Chief Justice and the President of the Supreme Court, this particular place went into celebration. The residents here are excited, and it is actually on another level. As you can see behind me, a number of them are continuing with their celebrations. Of course, traditional songs from the Kalenjin community is the one renting the air, and joining me is a number of them just to tell us their views about the pronouncement from the 7-judge bench. Asante sana, karibia hapa, naona umevalia magwanda haya. Pengine tueleze kwanza unaitwa nani na mbona uko katika hali hii, na umechukuliaje uamuzi uliotolewa na majaji wa mahakama ya upeo?
No, first of all, let me start by introducing myself. My name is Kevin Kosge. This is the region where I belong. Mimi ni mkazi wa hapa Uasin Gishu, nimezaliwa hapa. Kwanza mimi nina furaha zaidi, manake nina furaha kwa sababu nimeweza kupata president ambaye anatoka area hii. Ni furaha, ndio maana naona nimevalia hii kitu hapa. Hii kitu kwa Kikalenjin tunaita sinendet. Hii ndio sisi mababu zetu ndio tuambia, hii ndio kitu za zile mahali kuna sherehe, mahali yani any ceremonial yenye inaendelea. Hii sisi kwa kwetu ndio maana unaona tunavalia hii kitu hii. Mimi kwanza nina furaha kabisa. Asante.
Pengine nipate mwanadada, pengine songea hapa karibu. Ruto ametangazwa kuwa rais mteule, na uamuzi ule majaji umekuwa ukisubiriwa zaidi. Pengine matarajio yako ni yapi na unahisi kivipi baada ya tangazo hilo?
Kwa majina naitwa Masi Chepchirchir, mimi mkaaji hapa Uasin Gishu. Tuko na furaha tele. We just say congratulations to our president elect. Thank you.
Asante sana. Pengine kijana songea hapa, wewe vile vile umekuwa hapa, matarajio yako ni yapi wewe kama kijana? Maanake tunazungumzia kuhusiana na kuchukua kwa ajira miongoni mwa vijana.
First of all, my name is Jackson Maya. We are so happy by what the Supreme Court has just announced. Tunafurahia sana. We want to say congratulations to Anaitwa Doyen William Samoei Ruto. Yeah.
There is another lady who has been praying all through when the 7-judge bench, of course, when the Chief Justice and the President of the Supreme Court was making a number of issues regarding to the presidential petition. And I want to understand what was going on. Unaomba wakati ambapo zoezi hilo lilikuwa linaendelea. Pengine umehisi vipi na unaona kwamba wale majaji wameweza kutoa uamuzi ambao ni wa busara?
Bwana asifiwe. Kwa majina naitwa Pastor Rosti ya Mtai na ubiri taoni. Ombi langu lilikuwa naomba tu ya kwamba Mungu asituaibishe, atuinue kutoka kiwango kingine hata kingine. Maana tunajua kwamba Biblia nasema kwamba katika kitabu cha Isaia 54 mstari wake ni 17, kula silaha kinyume chetu haitafanikiwa. Nilikuwa nasema kwamba kuna silaha kinyume chetu ya kupangwa atakayofanikiwa kwa maisha yetu. Maana sisi ni washindi na you are more than conquerors in the name of Jesus. Mbarikiwe na neema ya Mungu tutoshe. Amani, amani, amani ya Yesu.
Asante sana. Pengine una maoni vile kuhusiana na swala hili tukitamatisha, nini kipi ambacho unatarajia kwamba Ruto ataweza kufanya au matarajio yako kwa rais mteule William Ruto?
Mimi kwa majina naitwa David Mokuria. Naweza tarajia apunguze bei ya unga na mafuta. Sana sana hiyo ndio muhimu kwa imeleta shida sana.
Pengine swala la ajira?
Ajira kwanza kwa sisi kama vijana kama sisi tumemaliza shule juzi. Tunataka ajira itokee. Kama mimi nimesomea agriculture, naweza penda agriculture.
Asante sana. Wa mwisho pengine mwanadada, unaona vile umevalia kijunji hapa, pengine ukiteremka hapa chini, wewe unahisi vipi? Na vile kwa mara ya kwanza wale majaji wameweza kutupilia mbali ile pendekezo ya wale ambao walikuwa wanapinga rufaa au kupinga uamuzi wa Kenya kuhusiana na William Ruto kuchaguliwa. Pengine unasema nini?
Niko na furaha sana. Kwa majina kwanza naitwa Eunice Bunai kutoka Moiben hapa Wasingishu. Niko na furaha sana kwa siku ya leo kwa sababu ni mara ya kwanza tukipata president amewania kitu for the first time na amepita. Kwa machache tunawashukuru. Congratulations sana Martha Koome.
Asante. Wa mwisho?
Kwa majina naitwa Kipchirchir Evans. Mimi ni mkaaji hapa Eldoret. Nashukuru chaji kwa kutupatia president William Ruto. Niko na imani William Ruto atakuja kutusaidia sisi wakazi wa Eldoret, hasa sisi watu wa bodaboda. Tuko na imani naye sana kwa promise inakuwa tumepromise. Tuko imani sana atakuja kutusaidia kwa hapa Eldoret.
Kwa sasa kuna wale ambao walikuwa wanataraji kwamba pengine Raila atatangazwa. Wito wako kwao ni nini hasa ikizingatiwa kwamba Wakenya waliweza kushiriki katika zoezi la uchaguzi, Ruto alipotangazwa wakawa na amani? Unasema nini kuhusiana na swala hilo?
Mimi nawaambia watu wenye kwa side ya Raila wakuje pamoja tufanye kazi. Hii injini yetu na hii injini ya kila mtu, injini yetu sisi wote.
Wito kwa watu wa Raila nawaambia karibuni Kenya Kwanza, tuunde serikali mpya pamoja na Kenya Kwanza. And kwa Raila, there is tomorrow, my leader.
There you have it, my colleague there at the broadcasting house. The excitement is immense. A number of them are having expectation that William Samoei Ruto, once he is sworn in on 13th of this month, is going to deliver a number of issues. Of course, the bottom-up economic model that he promised the Kenyans all over the country. And of course, also they are having confidence that William Ruto will address the issue of unemployment, and of course also the issue of the bleeding of the burden of the high debt in the country. A number of issues that actually was in the manifesto of